Good morning. Thank you for joining Anne-Marie and myself, Merritt Green, for 20 estate planning questions, or we call it sometimes Ask Anne-Marie, all the questions that you might have about estate planning that you haven't been able to get answered. So it is 11 o'clock. We will be finished by noon. So with that, why don't we go ahead and start the presentation. During the presentation, there is a questions tab in the GoToMeeting or GoToWebinar toolbar. Please use that to ask any questions, and we'll try to get them immediately answered, hopefully by Anne-Marie. You really probably don't want me answering all of your estate planning questions. And with that, I'll give a quick introduction of General Counsel. Anne-Marie will give a little introduction of herself, and then we will go into the 20 questions. So just very quickly, General Counsel, we're a full service law firm. We were founded in 2004. We serve as legal counsel to small, medium-sized businesses, nonprofits, and individuals throughout the DC metropolitan area. And we represent a number of companies and matters throughout the country. We have 6 primary practice areas: corporate, business law, labor and employment law, government contracts, dispute resolution, litigation, family law, and estate planning, asset protection, which is why we're here today. Anne-Marie, do you want to give a little of your background?
Absolutely. First, welcome. Thanks for joining us. I know sometimes estate planning is not the most uplifting topic, but we're going to try to keep it light and relevant to actual situations and real questions, and not try to sound too much like legalese. So I specialize solely in estate planning. Love working at General Counsel because we also collaborate with the other practice areas that Merritt mentioned. So whether you're going through a divorce, we have a family law attorney that sometimes impacts estate planning. We also have small business clients that we do business succession planning with. And of course, I specialize in doing wills and trusts, all different types of trusts, and making sure people are prepared for whatever unfortunate situation may or may not occur. And I went to Syracuse Law School, same school as Merritt did back in the 90s, and we'll leave it at that. Hopefully I don't look my age.
Great. And I guess there are a number of reviews on our website for Anne-Marie. Here are 2 that just talk about how thorough she is and how she cares about her clients, and really does a great job for her clients. So if you need estate planning or you have any documents already in place that need to be updated, please consider calling Anne-Marie. And I know that she is willing, I think, to give a free consultation for anyone who's participating today in this webinar.
And thank you for the people who already reached out for consultations. And if you haven't done that yet, you can definitely reach out, and I'll send you my calendar link, and we can have a quick call and answer any questions that we don't cover here.
Wonderful. And with that, we'll move on to our 20 questions. A quick caveat, don't take this as legal advice. We're giving general information. Everyone's situation is unique. So this is fairly general information, but don't take something we say today as legal guidance that you make legal decisions on. You should always talk to a lawyer first. None of this is meant to be legal guidance for you in particular. You should have an attorney-client relationship to do that.
Yeah, we just really want to provide a good overview so you can understand some of these terms that you hear. There's all these blogs out there and lots of information you can, do it yourself type of information. And we just want to cut to the chase to, either verify or not verify or put you in the right direction. And happy to speak with you if something needs more clarity for your situation.
Perfect. So I always get confused personally about the term estate planning. I really don't have an estate. When I think of an estate, it is, a duke living in England with a large estate and lots of stone walls. So when we use estate planning, what does that mean?
Estate planning really can mean a lot of different things. I think that's why it's confusing to people. So of course, those people who live in those big castles and they have the big gates in their house and all of that, that's considered an estate. But even a person who is just has a job, a 9-to-5 job, who owns an apartment, and has one bank account, they also have an estate. So an estate is the assets that you own, anything at all that you own. And it also addresses other things if you want to expand it. It also goes to your healthcare decisions, what you want. We call it final disposition, so burial or cremation. But it also covers things if you're doing it the right way, best practices, if you're incapacitated. So estate planning can talk about your assets, but also pre-planning, so your decisions, what you want to happen with the stuff that you own and with your body, can be effectuated legally.
Yeah, as I like to think of it sometimes, it's sort of empowering the individual who's going through the estate planning process. And that's either an individual, it is a husband and wife, and it's empowering them, to make decisions, what happens to their assets, what happens to, for medical decisions, financial decisions and the like.
I forgot to mention also privacy waivers. That's a big thing nowadays that sometimes people don't talk about. We have a lot of privacy rules and, with social media and different things. So estate planning also covers waiving privacy in case that information needs to be accessed for whatever reason.
Well, just quickly, how does that work then exactly? So if a client's meeting with you for estate planning, how does the privacy protection, how is that implemented?
Yeah, so we go through a deep dive of what accounts they have or what social media they use. For example, just say Facebook, for now. And within Facebook, there's controls that someone can do it yourself to assign someone to take over their account if they're incapacitated or when they pass away. But also there's a document that we create that references the different accounts. And that way, if there's any question whether someone can have access, they could show this document and say, look, I was the agent for this person and they waived all their privacy rights and allowed me to access them. I don't want to get too negative, but if there's an autopsy or something that's questionable, things like that, sometimes social media can help, and sometimes it's hard to access that. If you have this form, you needed that information, it really streamlines things. And then we'll talk about the power of attorney a little bit later, but in a power of attorney, you can also reference specific accounts that you want people to access or not access. You don't have to give a full blanket waiver for everything. You can be specific because maybe there's some things you want to keep private. But it's a good idea to at least make the decision so what you want could happen, and you could assign those waive those privacy rights to whoever agent you want to have access to.
Gotcha. All right. Well, let's then go into some bit more of the nuts and bolts. So question number 2, what are the most common tools used in estate planning? And I know some of these we're going to go into detail. So perhaps just a quick overview here, and we'll get into more details as we go along.
Well, everyone's probably heard about the will or your last will and testament. There's also another type of estate planning. The main document would be a trust, all different types of trusts. Then there's a power of attorney, an advanced healthcare directive, a living will, the privacy waiver, final disposition. And for people who have minor children, there's also a guardian nomination, which is important as well.
Mm-hmm. And there are probably 50 different types of trusts you can set up. So, but we'll get into that, I know, as we go on too. So what's probate? Often folks talk about probate as something that you want to avoid. What is probate and why should I care?
So probate is the court system where assets that are not placed in a trust typically are administered and given to the beneficiaries who you have mentioned in your will. But sometimes trusts are also brought into probate if there's a question about the particular trust. So it's generally the court process that manages assets and debts of someone who has passed away. And this process is usually very slow. It's very deliberate. It's arcane. It's a lot of paperwork. COVID has actually streamlined the courts because they were inundated with a lot of this, and so they've had to learn how to have more online filing and easy access and things. So in a way, COVID has helped this a little bit, but it's still a court process and it's still expensive to go through. So if you can structure things to avoid probate, that is better because it saves time and it saves money. Because going to probate and that whole process is sort of like a part-time job. It's a court system and they're only open certain hours, et cetera, et cetera.
Mm-hmm. Well, and one thing we do as lawyers is help people through the probate process. You said that you can go to probate if you have a will, you can avoid it with a trust. What happens if you die without a will? That's passing away intestate, right?
Yes, thanks. I forgot about that. I appreciate it. Yeah, so if you don't have a will, that's still the court system where you go through. If you don't have a will, whatever state that you're in, they usually have a process, and they explain, if you don't have a will, where your assets will be going, whether if they go to your spouse, if you have adult children, and they make the decision based on a statutory scheme. So even if you don't have an estate plan, going back to number one, your actual state where you live, they have a plan for you, and that's the intestate succession plan.
And you don't have a choice in that matter. So, husband and wife, everything will automatically go to the wife, which most people would want generally anyway. Although, as we talk with our family law attorney and folks going through a divorce, we often will go in and do some estate planning as they go through the early stages of a divorce process. But then it goes to, if you don't have a spouse, maybe it goes to, is it next siblings, or would the next would be parents and children?
Parents usually first, and then siblings. And also, there's a process that money gets spent trying to contact these people too. So it's not just the court process, the attorney you're paying for, but information has to go out to try to reach these relatives. And how far down the line do you want to go to do that? If you can do a little planning yourself, then your hard-earned money that you've saved is not going to go for this administrative procedure.
So really, it's if you haven't done some of the estate planning, you almost your family descendants will be paying money going through probate. So it's almost better to do it beforehand, have a plan, be in control, and really it makes a much better process. So number 4, what's a medical directive and why do I need one?
Yeah, an advanced healthcare directive, it's called a lot of different terms, but basically it's a directive where you assign an agent or a personal representative to make healthcare decisions on your behalf. It can be a form document, or it can be more customized, which is what we do. We have different hypotheticals for different situations, and we go through what would you want in this situation, what would you want in this situation, and we also give the agent, powers to do different things based on what you would request. And that document can be communicated to your family and friends, so everyone's clear on what type of health decisions you prefer in different circumstances. But it also can be uploaded to your healthcare portal, just so everyone is on the same page about what you want. And nowadays with the pandemic and all the different treatments that they tried, and some people are open to, some people are not. Some people want to have vaccines, some people don't. Some people don't want antibiotics. Sometimes people do. So people are getting more clear about the type of treatment they want. And now there's even medically induced comas that treated COVID. And in that situation, you're a medically induced coma. How long do you want to be in that before they bring you back out, for example? So you can specify that information ahead of time, and that way, your wishes will be met. And we do that through a advanced healthcare directive.
So difficult decisions, but worthwhile thinking about. If someone gets in a car accident and they're in a coma, a lot of people have strong feelings on what happens at that point. How long maybe they're kept alive artificially, whether there's organ donation and the like.
Mm-hmm. And also in the way we do it, we also touch on healthcare insurance, whether or not, your insurance should be charged for certain things or not, what your wishes are in that respect. And that's important to put in there as well, because, things can get expensive with these different healthcare options.
Mm-hmm. Absolutely. What is a power of attorney and why is it important?
Power of attorney is a document that I always recommend we have if you have a will-based plan, because remember, a will only takes effect when you pass away, not if you're incapacitated or can't manage your own affairs. So a power of attorney allows you to name one person, or even more than one person, to stand in your shoes to manage your affairs. Or we actually have crafted specific powers of attorney for help people to manage their business if they're incapacitated or can't run it for whatever reason. It can run the gamut from allowing people to go to the Department of Motor Vehicles and talk to your bank accounts, or like I mentioned before, it can access social media, and it can go to investments. It can go to talking to the person who manages your retirement account. So whatever the day-to-day affairs that you normally do, or even if you manage something for someone else, you can delegate that power. And there's 2 types of power of attorney. There is a springing power of attorney that comes into effect under certain circumstances that you define. And it's really only a case of emergency, and there's an immediate power of attorney. So as soon as you sign the document, the person who you've given the power to has that power to act on your behalf immediately. So those are two different. If you have a power of attorney already, you can read that in the first paragraph. Usually it says whether it's immediate or not.
You know, and where this is important, I think, and for people to understand about estate planning is it's not just about, you know, what happens after you pass away. It's, you know, what happens if you're injured and can't make some of those decisions yourself. You know, whether you're a small business owner, whether, you know, it's for a medical power of attorney, medical directive. You know, I think it's, again, empowering the person to make these decisions.
And also had clients who are going to be out of the country for a period of time, you know, and they wanted to assign, you know, the right to communicate with us or communicate with other people regarding what, you know, their affairs and their business. So that's another issue that comes up. And frankly, it's out of convenience. Sometimes you want to name someone if you're going to be traveling and you want things to be running while you're not available for whatever reason. Or if you get shut out of the country, which happened to a lot of people because they had COVID and they couldn't get back in for whatever reason. It's important that someone has access to this so you can still pay your bills if they're not on auto pay and, you know, file taxes and things like that.
Although it wouldn't be bad having an excuse not to be able to file the taxes. Although I guess IRS would not accept that excuse.
No,
Right.
they find you. Actually, I had a client who came to me, and it was a small business client, and she did not realize that her husband had an agreement with her husband who had passed away from COVID, had an agreement with the IRS to pay so much a month. And as soon as he passed away, they actually came asking for payment in full for that settlement compromise that he had. So yeah, you just never know.
All right, question number 6. What's the difference between a will and a trust?
So a will is a legal document that's instructions to the court and instructions to your beneficiaries, or what you want to be done with what you own, and also with your debts. And sometimes it touches on taxes. Sometimes it'll also mention in there guardian nomination if you have minor children. And also sometimes it can include something about your final disposition, you want burial, cremation, but it's the instructions in one legal document about what you want to happen. So a trust is completely different. A trust is actually an entity that you're creating. So it has the instructions within it, like a contract, and it's almost, you can imagine it like an LLC or a small company, or even, you know, in lay terms, a box where you can put things into this trust. And based on the conditions you create in the trust, then that money gets dispersed as you've agreed in the first place when you've drafted the trust. So a trust is just a whole different animal than a will, because a trust is an entity, whereas a will is a legal document.
Are there certain, you know, clear-cut examples where you think a will might be better than a trust, or a trust, you know, clearly better than a will for a few sort of simple circumstances? If there is such a thing?
Yeah, I hesitate to say. I usually say it depends, but if someone just owns their own home and doesn't have a mortgage on it already, I still would, if they, you know, and they have a retirement account and some small savings, I still would recommend a trust versus a will, only because if you have real property, it sometimes takes a long time to have that transferred through the probate system, and having all those records updated. And if you do it ahead of time and you title the property in the name of a trust, which takes effect during your lifetime, not when you pass away, it's while you're living, then it's streamlined. Whether you're incapacitated or you pass away, there doesn't have to be a transfer, which is what happens in probate. But you know, sometimes people feel more comfortable with the will-based plan and having a will, and they just have to realize that sometimes it's going to take longer, and there could be, you know, delays, conflicts with a will. So I can't really say unless I look at the particular circumstance, and also want to know how much people are willing to spend, because with a will, you actually pay less on the back end. So you pay less for us to draft the will-based plan versus a trust, which costs a little bit more. But after you pass away, it's your beneficiaries and your relatives who have to pay by the hour to have the will probated. So with a trust, maybe you're paying a little bit more on the front end. With a will, you're paying more on the back end. So it's just really what works for your particular situation.
Gotcha. All right, let's go ahead and take one of the questions we have. And there's a little bit of an international flair to this one, so we'll have to see whether or not it's something that you can answer. Good morning. I'm married here in Virginia. My whole family is out of the country in Brazil, and all of them are Brazilians. My concern is the following: if my husband and I die, let's say in a car crash, then my family in Brazil would not have access to my assets. Would they not have access to my assets unless I had a will trust? What would your advice in that case be, so that I can assure my family in Brazil is contacted by the American system and has access to my assets?
Mm-hmm.
Let's see. Thank you.
Oh.
Let's see one here. Oh, okay. Go ahead.
I actually had a situation similar to that, and
They don't have children. Another fact that was just thrown in. No kids.
Yeah, there is a system where a non-citizen is able to get a social security number if there's a stated actual reason for it, even though they're not working in the United States. The same thing under the IRS. They have a system for you to get a tax identification number, even though you're not filing taxes.
And the person who asked this question is a U.S. citizen, so I'm sure they do have a social security number.
No, but for the other people. See, so what I'm saying is that in the will or a trust, you need to name a personal representative, whoever that may be. And that if that person, you want that person to be someone in Brazil, then that person needs to have some type of identification number for them to accept assets in your name, whatever that might be. So it could be through Social Security, or it could be through the IRS. But if you're here living here in the United States and you want to just name a neighbor or a family friend and then have the beneficiaries in Brazil receive assets, the same thing applies. If a beneficiary is receiving an asset, they need to have some type of identification number here in the United States to receive that. All of that is not a problem. You can just start the ball rolling now to get those forms, have them fill out information and explain why you want them to have it, and that they are not earning income right now, but you anticipate just in case you want them to have that.
Interesting. That is an interesting situation. All right. Question number 7. I've heard of a pour over will. What is that?
So a pour over will is the type of will that we draft in conjunction with a trust-based plan. So a trust, like I said, is a box that you would put, an entity that you would put whatever it is that you want. It could be a baseball collection, could be a house, could be financial accounts. But sometimes, after you come to our office and you sign the trust and we make sure it's funded properly, you decide to go out and buy, a boat, or you decide to go get a condo. And in between there, you didn't have a chance to title that property in the name of the trust. So a pour over will is exactly what it sounds like. It pours over the assets into your trust for all the things that may have been left out. That will does have to be probated, but it's a much more streamlined process because the court understands that you have a trust and just issues an order after reviewing that the items that you didn't put in your trust need to be placed in there. Sometimes it does get caught up, with taxes, transfer taxes and things like that because it wasn't titled in the trust, but it's a streamlined process so that way, nothing gets lost into unclaimed property department or anything like that. So your assets stay all in one place.
So a lot of times you'll have the house and, perhaps some other bigger things, perhaps life insurance would be in a trust, and then a lot of the personal possessions and other things might be included within the pour over will.
Yeah, it could be, specific distributions could be included in the pour over will. And usually when we draft the trust, we also have an assignment document, and that assigns your personal property to your trust.
Okay.
So it's sort of a pour over, the assignment almost acts like a pour over will for your personal property. You can put specifics in there, and then we also recommend having a personal property memorandum, whether it's jointly owned property or individual property, where you can list your different items and who you want to give that to. And that could even be, we haven't mentioned charity. It's kind of funny, we're already on question 7 to mention charity, but you can also, specifically give gifts to, museums or, any other non-for-profit that you think that would be appropriate for the various items.
Gotcha. All right. Can I simply buy life insurance for estate planning?
Short answer, no, it's not a good idea. Although, life insurance is, good for certain circumstances. I always make sure I raise it with the client to make sure that all their bases are covered. We don't sell insurance and we don't associate with any particular products, but sometimes it's important if you have a certain amount of outstanding debt, whether it's a mortgage or whether student loans, if that, or credit card balances, it's important to make sure that that debt is covered in some type of way. And life insurance could be one way to cover that, to make sure that people get a check outright upon your death, and that can cover various expenses. Some people even get that a small amount just to cover, their funeral or memorial service. So that's another idea. And of course, in the divorce situation, often it's used to cover future child support or spousal support obligations.
Mm-hmm. But estate planning, as we've sort of been talking about, is a lot more than just money. It's just more than passing on money, when you, if you die. It's what happens, all sorts of decisions apart from, when you die. It's, what happens if you're disabled or anything else along those lines. So life insurance might be a tool that you use to pass on money, especially for, younger couples with young children, other circumstances. But as we said, it's not a substitute. Question number 9, what are some of the benefits of using a trust?
There are a lot of benefits. I mean, we've talked about already that a trust is effective during your lifetime and also when you're incapacitated. So in contrast, the will is only effective when you pass away. So that's one benefit, is that you have a system already for your financial assets to be managed based on the way you want, based on the agreement. And within, when you talk about a trust, there's all different types of trust. There's, a revocable trust where you can put things in and take them out. So it's revocable. There's irrevocable trust, that things are placed in the trust and they can only be withdrawn for certain purposes. Special needs trust, I'm sure you've heard about that. That kind of works in conjunction with a care manager for people who have various special needs.
Spendthrift trust is one of my favorites.
Say it again?
A spendthrift trust is one of my favorites.
Exactly, a spendthrift trust. That way you can make sure that your assets are protected and protected from creditors. Lots of different types. But the point of a trust is it's an agreement based on your personal needs and that what would serve your particular family. So let's just say, for example, you have grandchildren and you want to make sure that their higher education is covered, or if you want them to go to a trade school or whatever is important to you for future education or employment for them, you can make that very specific, saying that X amount of money could be carved out for that particular purpose for them to do that, and they could have it at a certain age or on a certain, when they graduate from college or when they get a certificate or they have a full-time job. You can be very specific. I've also had clients that, just stick with the age. They want to make sure that their children or grandchildren receive assets that they put in the trust at age, 25 and then at age 35. But then there have been some creative ones also. People have said that they only can receive the assets if once they take some type of financial awareness or financial 101 budgeting course. They don't want them to get this big lump sum until they prove that they've done that. So lots of different reasons. And then if you're a husband and a wife or a couple, 2 people, if you have done any type of joint trust, whether revocable, irrevocable, well, I guess revocable we'll stick with just to be clear. When one person passes away or is incapacitated, the terms of that joint trust cannot change. It's fixed. So let's just say your husband and wife and you have 2 children and one person passes away. When the other person remarries, they can't change if they remarry, they can't change the terms of the trust. It's fixed. Versus a will, when someone passes away and you inherit your spouse's, all the assets that you accumulated together, you could remarry and you could use those funds for whatever purpose you want. So sometimes a trust can give people, just let them sleep well at night to know that their hard-earned money is going to go for the purposes that they intended in the first place.
Interesting. And then, of course, we haven't really talked about it, and not all of our clients, are in positions to need the tax planning, but there are all sorts of ways that you can use trust for tax planning. Whether it's for charitable purposes, whether it's for dynasty trust. There are all sorts of different types of trusts that can be set up to save monies on tax. And as you said, the irrevocable trust is a gift now. We're moving assets into the trust now, so that can avoid taxation, upon your death.
Right, and you can understand that in a way, because an irrevocable trust, you can't withdraw it. It's only for those specific purposes, like you said, in the future. But because you're giving up control, you get the tax benefit. Versus a revocable trust, you're not giving anything up, so you don't really get any other specific tax benefits for it. You just get the fact that you avoid probate, and then you have all those specific conditions that are important to you.
Yeah. We have another question here. Let's go. So, who or what entity controls the compliance with a medical directive, for example, in a nursing home or other medical facilities? How would it be controlled?
Yeah, that's a very good question. And, I hate to say this again and say it depends, but each of these different organizations, medical facilities, all have their own internal rules and procedures. The most important thing is to be able to communicate to your family members or your, the friends that you consider family members that you trust, about what you want, and then they can advocate for you. But if they do have this on file and you did have a primary care physician or a nursing home, et cetera, you can make sure that you communicate what you want with them, and then they need to follow that. But your point is correct. This person, what?
Yeah, if they don't. So in other words,
right.
you have a spouse who's your, designated as your power of attorney, your agent, pursuant to a medical directive, and let's say your siblings disagree with the decisions that is outlined in the medical directive and try to fight it. You have a legal document, and this legal document can be enforceable in court. So if you need to go to and have a judge say, this is a legally enforceable document, that is what the hospital needs to do, end of subject. So sort of answering that question, the hospital, the nursing home should follow the medical directive. Push comes to shove, you can go to court to force it.
True. And, but overall, usually they do try to follow, people's wishes as they're stated. It's just sometimes it gets complicated because they are not aware of the healthcare directive when they're first admitted, and, a treatment plan is created. But obviously, once they receive it, they should be able to adjust based on what your healthcare directive is. But yeah, enforcement is a big issue. What if you do all of this and no one even knows all these documents exist? So we really encourage communication with the agents that you're naming in your documents, so everyone is on the same page about what could happen. So we try to talk you through those conversations and how to best effectuate the plan. So it's great to have a plan, but it's even more important to be organized and communicate to everyone about it.
Well, and I think the importance of having some of these documents in place, the medical directive, if you foresee there being any controversy in certain circumstances. And one of the things that we as attorneys do is sort of come up with, the what ifs of life, the hypotheticals. What happens if you're walking down the street and you get hit by a bus? And what happens if you have, your sister who doesn't believe in medical care, and believes that, the planet Earth will heal you, and then you have another sister or brother who has a different philosophy, and then you have someone else, and then that they're going to fight, and no one's going to agree on how your care should be. That's why you need a medical directive. So you get to make that decision.
And we also, in certain circumstances, whether it's in the power of attorney, like making decisions for business, or in the healthcare directive, sometimes people want more than one person to serve as their agent for the very reason that you're saying. And then that's fine to name more than one person, but sometimes, like you're saying, it could be too many cooks in the kitchen for that. So you need to have a tiebreaker and specify that. The same thing in, in a trust, in a will scenario. You can't envision that everyone's going to get along. So it's important to have, if you have a committee approach, then you have to have a tiebreaker. That's just, the way it is.
They can. The documents allow you to be in control.
Right.
All right, quick question. And I think it's is a timeshare treated from the legal standpoint? And I think I can just handle that. The timeshares generally, you have a fee simple ownership of a timeshare, so it'd probably be treated like an ownership of a home, except instead of a full home, it's a fractionalized home or property ownership right that can be passed down through a will or otherwise. Obviously, you'd want to probably look at the timeshare documents, but generally they are owned in fee simple. Anne-Marie, have you ever dealt with sort of timeshares?
Mm-hmm. Yeah, you're exactly right. It's important to look at the specific documents before we can, say too much, because some of them do vary. But yeah, I've had some that I dealt with in Vermont. People have places they go up there and ski and blah, 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 and they want to make sure that they've gone there, their whole lives, and they want their children to enjoy it with their children. And you actually have to, make sure that whole the deed or the timeshare documents, whatever it is called there, is actually titled, if you have a trust-based plan, is titled in the name of the trust, so that can carry on. If you have a will, it's a little bit more complicated because sometimes these timeshares are not in the same state that you are. So that makes it a little bit more complicated with will planning, but it can be done.
Gotcha. Next question is, who holds the executor accountable that the wishes in my trust are carried out?
Mm-hmm. Well, really, the court does serve to make sure that the wishes within the will are effectuated, but they trust the personal representative to make sure that the executor, to make sure that those are carried out, so that the court is a self-check on that. And then if you don't think something is being done appropriately, if you're a beneficiary, then you can also, petition the court and explain, the circumstances of why you don't think, it is being done the way it was expressed in the will. So that's a process. However,
is it the same for a trust?
What?
Is it the same process if you have a trust?
Yeah, it is the same process, but usually a trust, the beneficiaries can request like the books and records, etc. So that can usually get worked out without going into court. There are a lot of provisions that are written in the trust to try to encourage cooperation versus legal action versus a will. But the way we do our wills, we actually have a lot of no contest clauses. So you have to be careful about that as well. And I think most attorneys do that for best practices. So if you are going to contest something, you have to check the will that you're contesting if you're a beneficiary, because sometimes if you contest, then you actually lose whatever benefit you might receive. So basically the whole you get what you get, but you don't get upset concept. But if you think that beyond your particular gift, that the executor is not doing what you expect the executor to do and upholding their fiduciary duties, then absolutely it'd be something that you could bring to the court's attention, and they'd be all over that based on the certain factual circumstances.
And I know one thing that we have some clients do is they'll use professional fiduciaries, whether that's a lawyer or someone else, to serve as the executor, and they have a fiduciary or ethical obligation, whether a lawyer or otherwise, to follow the wishes of the as outlined in the will or the trust. So, all right, well, it's 11:38, so we have 22 minutes and we're almost halfway through, so let's keep plowing through. I'm single, live in a condo, and have some savings and a retirement account. What do I need?
Well, the first thing that you need would be either a will or a trust to make sure that your assets are given to who you want them to be, and you don't have intestate succession issues. On the retirement account, it's very important to check your beneficiaries to make sure that they're updated. And I'm just going to put a note here that if you do name beneficiaries who are not yet 18, they need to, the account has to go to someone who is an age of majority. And so you have to name someone else to give it on their behalf for the benefit of, is what it's called. Because otherwise that whole retirement account will be brought into probate court because a minor can't receive the retirement account outright. And then for savings, same thing. If you're single, you might want to consider having a payable on death form or TOD, transfer on death form, attached to your savings account. It's not saying that the other person will own it jointly with you, but it's basically naming a beneficiary for your savings account to someone else. And that could actually keep it out of probate. So again, and oh, I didn't mention the healthcare directive. That would be very important as well.
Yeah, the healthcare directive, power of attorney. You know, a lot of single folks have pets. You know, so we see people set up pet trust, and you know, who's going to take care of their pets? You know, we're putting money aside for the care of the pet. You know, is something that we've seen a number of times. So there's still a lot of tools and things that you should consider, even if you are single, you know, and have the retirement account and live in a condo, even if you're renting. And of course, you know, if you have that retirement account, you want to make sure if it's a 401k, you designate your beneficiaries within those account documents. Number 11, my husband and I are separated and likely getting divorced. Should I update my will, consider a trust, or something else?
Mm-hmm. Big resounding yes there, because, you know, if you're separated, that means your goals and your interests are not aligned. And most likely that will continue if someone is incapacitated or when they pass away. It could be that, you know, the other spouse has a relationship with someone else. So if you want to protect your assets and you want to make sure that your decisions are managed the way you want, then it's important to have those documents updated much sooner than later. So you have someone, a friend or family member, acting in your interest, in your best interest.
Yeah, that's something we've been talking about more and more with Joanna Ford, who leads our family law practices. You know, if someone's getting separated, going through the divorce process, you probably one of the first things you want to do is update some of your estate planning documents. Because
you already have legal fees for divorce and whatever. You don't want to have to open that whole door for if you're incapacitated or pass away and have your money go to legal proceedings to untangle all of that. It's just better to have it clean and update your will or your trust to meet your current goals in your current situation.
Oh, absolutely. In Virginia, if you have children, it's 12-month separation period before you can start the divorce process. So if, you know, something happens during that, you know, 12-month period while you're still legally married and the divorce process hasn't started, again, you want to be in control of what happens to your possessions and other things. All right, question number 12. My daughter is married. If she predeceases her husband, who has children from a prior marriage, how can we make sure that he does not inherit our money?
It's a very common question, actually. You have to be very specific about who you're going to give the gifts to, naming them, you know, with dates of birth and all of that, and be specific and disinherit other people. And another idea that we suggest is having a financial guardian, not just a guardian, because obviously they're your grandchildren, not necessarily your children. Have a financial guardian, and it could be a sibling even, to manage that gift that you wanted to give to your grandchildren. That way, you know that her husband is not going to manage things or mismanage things. You know, it's just that his responsibility would just be to raise the children, because obviously they have parental rights, but the gift could be given directly to the children if there's a financial guardian.
Now, you're talking about a gift here. What about a will or a trust? It almost seems as though what might be best here is set up a trust. Yeah. And the money would be in the trust for maybe the use and protection of the children, but there'd be severe limitations on the husband's access and or use to it.
Right. I meant a gift through a will or a trust. So if someone had a will, they could the court would actually create a trust on behalf of the children and have someone else manage it. And in a trust situation, then the trustee would already have the instructions in there about what were permitted uses of the funds.
Mm-hmm. You know, it's interesting, and this is almost brings into play a little bit of our family law discussions that we have as to what is marital property and what's not. You know, so if this daughter in this scenario, the parents pass away, and let's say the daughter gets $1 million. If the parents really want to make sure that money stays separate, they may want to designate that into a separate trust, that so it does not become a marital asset. So that if she then predeceases her husband, it continues to be separate. Because if she's just given the money, otherwise it could really become a marital asset. If she's given $1 million and they jointly buy a house, that becomes commingled monies between the husband and wife, and the wishes of the parents in that regard would, I don't think, be in control anymore.
And that term, when it just gives it the $1 million to her directly, it means it's given outright to them versus putting it in a trust or a will with other conditions in it.
Yeah. All right, question number 13. My grandson's great, but he's struggled with addiction and debt for the past several years. What can we do? This is the spendthrift trust I was talking about.
It's spendthrift trust. Yep, it's a very good idea to do, and it can protect the assets for when the trustee thinks that the grandson is more financially mature, or it can actually give it out. What?
What are some of the terms of a spendthrift trust?
Well, basically, it's all this legalese, but it says the assets that are placed in there cannot be used to satisfy the debts of the grandson, for example. So let's just say you racked up a lot of credit card debt. That money can't be accessed to satisfy his debts. It can only be used for certain purposes. So it basically carves out money away no matter what the grandson does. And then it also has conditions for the trustee, who would not be the grandson, to distribute the money under certain circumstances. If he needed money for rent, if he needed money for health care, basic needs to make him feel comfortable, a car so he could get to his job, things like that is one example. But a different, what?
He couldn't go on a bender to Las Vegas with, $100,000. The monies are controlled by the trustee and only doled out in certain circumstances.
Yeah, and often in there, it's actually direct versus giving the money to the grandson. So it takes out the middleman and goes directly to whatever caregiver is helping them out, or directly purchasing the vehicle or whatever. It's a little bit more work on the trustee's part. But also, if someone is an addict, there are also controls on there to make sure that before they get the money, you can make sure that they're clean. The trustee can make sure that they have proven that they, have not been, using for a period of time. They can have them show a drug test. So you can put those controls in there. And then you can also have even though it's not traditional special needs, someone like this sometimes has a special needs trust, or it could be characterized in that way because they need treatment, more than one. Sometimes people need to go away for treatment more than one time. The first time it's not effective. So you can allocate money for that as well.
Okay. And I know we're going to talk about special needs in question number 16, but for number 14, we recently purchased a home. We moved from Oklahoma to the Washington, D.C. area. Should we update our estate planning documents?
Absolutely. Yeah, I think it's the perfect time to do that, because you're in a new place, you want to get organized, and you want to consider how you own your property. Do you own your property as husband and wife? Do you own it in an LLC? Do you have a trust already that needs to be updated because the laws here are different than where you moved from? So it's just something that you need to review. No need to create a mountain out of a molehill, but do something to structure everything going forward so your assets are protected under the laws where you move.
And if you already have, let's say, trust in place, you sold the house in Texas, or Oklahoma, and so your primary residence is no longer in that trust. I imagine you could buy your new property here in Virginia and transfer it into that pre-existing trust.
Yes, you absolutely can. And one thing people often don't realize, if they have a trust and they have the house in a trust, they always have to make sure that they have a bank account also associated with the trust, not just the property in the trust, because once you get that check from the closing, you have no place to deposit it because you wanted to keep it within the trust. So make sure you have the bank account and have the deed updated, both.
I'm at number 15. I'm a divorced dad with 2 kids from my first marriage. now remarried, expecting another child with my second wife. How can I protect all of them except my ex-spouse?
Mhm. Well, we often do disinheritance provisions. So we are very clear, like I am married now, and you list who your former spouse was, saying that you do not want them to receive any of your assets, and except for, you know, anything that relates to caring for your prior children. So it's carving out something for your two kids from the prior marriage, and then allocating assets for any future children that you have and your current spouse. But it is easiest to do that in a trust-based plan. It gives you more flexibility to grow with it. And like I said before, that is fixed. And so even if you're incapacitated when you pass away, those conditions that you stated originally are fixed. And it can grow with you too, it could be expanded to whether you're going to adopt, or you're going to do in vitro, or, you know, whatever other situation you want to anticipate. So that's a wonderful thing, and a wonderful reason to do estate planning, because, you know, you're growing and changing, but you still, you know, want to make sure you're providing for, you know, your two kids from the first marriage. So it's a great idea.
And the second wife may want to have a trust in place because, you know, when push comes to shove, she may want more of her assets going to her natural born child than the children from your first marriage, the husband's first marriage. So,
and usually in that situation, we can do, it's easiest to do a combination of trust, you know, so it would be a trust with the divorced dad alone, and then the second spouse could have their own individual trust, and then it's up to them if they want to have a joint trust together. So that way it keeps all of that very clear.
And I think that's one of the things to sort of highlight again today is it really puts the client, what we try to do is put the client in charge, because everyone's circumstances are unique, and we have a lot of tools available to help in that regard. So, all right, 9 minutes to go. Special needs child, what sort of estate planning options do I have?
So we talked about that a little bit earlier, that a special needs trust is a great way to go. You can be very specific in here, like just say, for instance, your special needs child likes to go to this particular park, or likes to have, you know, watch this show on a particular basis, or loves this caregiver, or needs this type of therapy on a regular basis. You can be very specific, or you can just be very general, setting aside funds to go to the special needs of your child. And this child could actually end up being your adult child too. It doesn't just have to be a minor child.
Great. All right, I've read that trusts are used for tax planning. I know we've talked about this a little bit. How common is it to use trusts for tax planning?
It's very common. I mean, it's one of those things that depends on everyone's financial situation, but it's on the minds of most people. You know, most people don't want to have more of their hard-earned money going to the government that they don't have to. And if there's a way to protect it, they want those provisions in there. And those can be included in a will as well, not just a trust-based plan. So you can make sure, but the important thing is that the tax laws change all the time. So that's another reason to have your existing documents looked at so they can be updated based on the current laws.
And I know there's certain federal exclusions for federal tax now. You know, and as you said, that does change. But, you know, if you're over those exclusionary limits, you know, then you really do want to consider some tax planning, and the trusts are a great vehicle to do that. Question number 18. I plan to move when I retire. Should I just wait to do my estate planning until after I move?
It's just one of those easy justifications / excuses that people have. The answer is no, because what if something happens now? And then everything, you've been putting things on hold for when you move, and then in the meantime something happens, and then your friends and family, you know, are stuck. But the second reason is because most states actually have adopted uniform codes, meaning that the statutes and the laws for estate planning are pretty much streamlined across the United States if they have adopted those codes. And most of the states have reciprocity, and or portability. They recognize a will from another state, or a power of attorney, et cetera, et cetera. It might not be perfect in all situations, but it's much better to do it now versus wait.
Well, and also, as we've talked about, the what happens to your property is just a small part of the estate planning, you know, process. You know, it's the medical directive, it's the power of an attorney, it's, you know, being in control. And if you wait just thinking, oh, I'm going to sell my house and move and buy a new house in Florida, you lose all of those other abilities if on the car ride down to Florida the U-Haul blows a tire, flips, and you die. Just to throw a cheery fact out there. So
well, also, there are those special items that a certain family member treasures that you have. Like, did you sit down and have, tea with someone on a regular basis? Or did you go to a baseball game and you have baseball card collection, or different things like that that meant something to someone in your family, whatever that may be. I had one the other day that was a special type of bread maker, kitchen item that they wanted to give to a specific person that found that important to them. And you don't want that stuff to be lost in translation, rather than have it write it down now.
Absolutely. All right, question number 19. I'm a small business owner. My family depends on my income. Is there a way to protect them with estate planning if anything unfortunate happened to me, whether disabled or dying?
Mm-hmm. Yeah, absolutely. That's a really great reason, because people are dependent on you, and you want to make sure that your assets are aligned in a way that people can access them, that people could be a signatory on your account, keep the business running. Also, you don't want to let your clients down that you've already made contracts with, or they're depending on you to come through. So yes, we do business contingency planning. It's a deep dive into the business, but also it touches on your personal needs to make sure that all these different scenarios are covered, because like Merritt said earlier, it's our expertise to think about all the what ifs, and we cover them through estate planning. And a big piece of that is a customized power of attorney that addresses the business needs, but also the personal needs.
Well, and then what we'll also do is sort of the business succession planning, working with some of our corporate attorneys. If it's a business you own yourself, you have a few key employees, and perhaps you put in a buy-sell agreement that's funded by life insurance. Or, if you have other partners, again, within an operating agreement or shareholders agreement, are there buy-sell provisions that if something happens, there is a buyout? Oftentimes for that small business owner, the business itself is one of their biggest assets. So you want to make sure that you get the value of that asset. In fact, tomorrow, we're actually doing another webinar with Joanna Ford, who leads our family law practice, and a CPA, Richard Wolf, talking about valuation of businesses. This is as relevant to divorce, but I think it's important for estate planning also. For that business owner, this is a big valuable item as a business, and how do you treat it as part of that estate plan and that planning process? All right, so we have 3 minutes to spare, so we are great. So Joanna, in your in your years of helping clients, what's the most important advice you can give them?
I think the most important advice is not to delay, like we talked about before, to try to organize your assets, look at what you own, how it's titled, and decide, what you want to happen. Make the decisions. There's actually no good reason to delay, because something could happen and then, you're not protected. It doesn't actually take that long to do legal planning. You just have to have someone guide you into your options and what your decisions are. And, here at General Counsel, we welcome the opportunity to work with you.
Wonderful. So I think that we've answered a lot of the questions as they've come along. I know we have here that Joanna, that Anne Marie would be happy to have a free consultation with anyone who's part of the webinar today. And obviously, if there are other things that we could help you with, please do not hesitate to reach out to us. And final thoughts, Anne Marie, before we sign off?
Well, congratulations from you being open to this topic and learning more about it. Some people, it's just so easy to stick your head in the sand. So you should give yourself a pat on the back to even being open to attending our webinar. So thanks for joining us.
All right. Thank you so much. And please contact us with any questions. Bye-bye.